Good morning, everybody, and thank you so much for joining me on today's Total Attorneys Power Chat. Our guest today is CEO and founder of NextPoint, Rakesh Madhava. And NextPoint is the leading developer of cloud-based technology products for legal and compliance needs. Using a highly secure data cloud, the NextPoint platform integrates applications, processing, storage, and support throughout the legal process, from preservation through resolution. NextPoint is dedicated to a simple but essential mission to deliver world-class customer service with an uncompromising commitment to engineering and design. And Rakesh, thank you so much for your time and sharing all of your insights on e-discovery with us today. We're really excited to hear your thoughts on this topic, and you have a wonderful suite of solutions that you're providing to solos and small law firms today.
Thank you for having me. I'm excited to be participating in the Power Chat, and thanks for the time.
Oh, no problem. Just a couple of housekeeping notes before we jump into today's topic, e-discovery for solos and small law firms. If you have trouble during today's session, you can email powerchathelp@totalattorneys.com, and someone will be available to assist you with any technical issues. And if you have questions for our speaker, we'll be covering those at the end of the hour. And you can chat those in the GoToWebinar tool, or you can also email powerchat@totalattorneys.com, and we'll make sure to get those in before we wrap up today. So jumping into the session, our first slide kind of covers what is e-discovery, and I think there's a lot of mystery or misunderstanding around this topic. So Rakesh, if you could kind of walk us through what are really the basics of e-discovery and what do we need to know?
Sure. Well, you know, before starting NextPoint, actually, when I first started my career, I started out as a paralegal in a law firm. And when I was a paralegal, the process for discovery was that you would go into somebody's office and essentially look through their office for any relevant documents. You'd open their desk drawer, you'd check out their file cabinet, and you'd put a tape flag on anything that needed to be produced in the litigation, and then you would send it to a copier, bait stamp it, and send it to the other side. And that process is largely, an anachronism at this point. And the focus now of discovery is on electronic files, and that's a recognition of the change that the internet has brought in the way that we work on a daily basis, and the changes in desktop computing and the use of word processing and spreadsheet applications as well as presentation applications. So the E in e-discovery is for electronic. Really, there is no such thing as discovery without the E anymore. Almost all discovery, if not all discovery, retains an electronic component to it, again, because of the nature of the changes in the way our society does business today. So any piece of electronically stored information is potentially discoverable. As I said, there's no longer any discovery that that ignores the existence of any electronic files. And the interesting thing about it was that the first, wave of e-discovery would be that people would ask you to print out an email box or print out all the WordPerfect files. And so you would take what was an electronic file and turn it into a paper file and then kind of carry on the same process that you did before. And again, the volume at which this electronic data is being generated has made printing it out no longer a feasible strategy, as well as a whole host of issues around metadata and the associated information with electronic files that courts have decided are potentially relevant. So not only is a spreadsheet potentially relevant, but the formulas within that spreadsheet or the open and created date are also potentially relevant as well. And those are pieces of information that aren't captured when you just print it out. And increasingly, we've seen the courts take a more aggressive stance about e-discovery, that the not having a proper e-discovery process in place actually results in sanctions, and oftentimes also results in the judges taking an adverse inference about the disposition of the underlying case, so that what in the absence of electronic data that records a particular transaction or a particular issue, the courts are assuming that because electronic files were destroyed or were not able to be produced about a relevant period of time or from a relevant custodian, that there must have been something in there that would have essentially demonstrated that the party was liable for whatever they were being sued for, and have directed adverse inference motions as well.
And do you find that it's very challenging to keep all of these different data sources, not only keep track of them when you take on a new case, but also just find technology that allows you to centralize all of the data in one location?
Yeah, definitely. I mean, I think the major challenge for attorneys in starting the e-discovery process is basically figuring out what to do with the electronic files. It's pretty easy to figure out what to do with the stack of paper, but if somebody sends you an email box or a set of spreadsheets, what to do with that for most attorneys is a new process and is requiring some learning and some investigation about the technologies available in the marketplace, about the different kinds of software products and applications and storage providers that can assist with the e-discovery process, and has really created an entire burgeoning industry of e-discovery vendors. We're one of many, but you know, this fundamental problem, and the parallel I'll make is for it's similar to doctors needing to understand what drugs they can prescribe. It's similar to, you know, the military having contractors that help them build tools to be an effective military force. The technology relationship for lawyers is now a critical and necessary component of their daily practice.
Got it. And let's dig a little bit deeper into what is ESI exactly. It's not necessarily data or files that we're used to dealing with, or that, you know, have been readily available to us, or that we knew that we needed to track and retain for extended periods of time until a few years ago. So let's dig in a little bit to what exactly is ESI.
Great. And so ESI is, and the term ESI comes from the amendments to the Federal Rules of Civil Procedure that were updated in 2006. And the interesting thing about it is it doesn't identify specifically what can be considered as electronically stored information. So one of the resources, if you want to really kind of dig deep into the thought leadership around electronic discovery and its implications for the law and the sort of, you know, academic legal understanding of the framework, the legal framework under which electronic discovery is being understood, really the leading thinkers about it are the Sedona Conference. And the Sedona Conference is a nonprofit institute dedicated to improving the administration of justice in a reasoned and fair way. And Sedona publishes a number of publications every year and works on a number of papers and working groups at any time that are designed to give practitioners and judges guidance as to emerging issues in the law. And so we look kind of at the Sedona definition, and Ken Withers is the director of the Sedona Conference, and he's written that it's understood to mean information created, manipulated, communicated, stored, and best utilized in a digital form. So it really has far-reaching implications as far as when you think about the types of things that we do on a digital basis, and the types of things that could potentially be relevant in a particular litigation that are done on a digital basis. It's a very broad definition. So voicemails, instant messages, calendars, obviously, audio files, data that's specifically held on handheld devices, so text messages, for example, animations. The metadata around all of these are significant issues as well. It's one thing to store the electronic stored, to capture the electronically stored information, but you also need to be able to point to what the metadata is around it. Graphics, photographs, spreadsheets, websites, and really the cutting edge of this is expressing itself in social media. And we've seen studies where Gartner has projected that by 2013, half of all companies will have been asked to produce data out of their social media. And we've also seen a study by the American Institute of Family Lawyers indicating that a survey of their attorneys is that 80% of family law practitioners in divorce proceedings are going to Facebook as their most significant source of evidence in their cases. So social media has only added yet another data type to this already exploding landscape.
Yeah. And these are not files that we would typically, I mean, nobody's screenshotting their Facebook page. So let's talk a little bit about where is this ESI data actually stored by the clients.
Great. I think for attorneys, and on a really practical basis, the first question to ask your clients when dealing with e-discovery is, where is your data stored? And it's actually, for as complicated as it seems, and for the number of potential places where this data can be stored, it can be a relatively direct process. And the fortunate thing is judges, while they have issued sanctions for lawyers who don't do anything or seemingly ignore electronic discovery, for people who take a relatively sensible, proportional, direct approach, the judges have imposed a proportionality standard that says that data that's basically reasonably accessible. So that would be, data that would be email boxes for specific custodians. That would be the computers and the hard drives of custodians who may potentially be relevant to litigation. Flash drives, thumb drives, CD-ROMs, any external hard drives, and mobile and portable devices. And so the first process here is what is called the collections process. And so for attorneys, really the first step is to sit down with your clients and understand their data landscape, understand where the most relevant data stores are, and how accessible is that information.
And by accessible, do you mean that they can just reference it at any time, or are you talking about accessibility in terms of actually searching through that data looking for particular pieces?
Well, and it's a great question, and it's really the most interesting part of, I think, the e-discovery challenges is that it depends. And emails are pretty easy to get at and look at. Now, if you're looking at a proprietary database with customer records, that can be a little bit more complicated to produce out of. If you're looking back at historical materials that are on backup tapes, on magnetic tapes, or have been taken offline in some format and put into an archival system, those are even more difficult. And so the job of the lawyer there really is to assess what is a reasonably accessible set of information, and advise not only their client but also the court and opposing counsel on the availability of some of this data.
Which kind of brings us to our next slide of the how do I get to it, or how do I get the data that I need. And you're saying if you don't know how, don't learn how, or send a notice of litigation hold. What would be your advice if you are looking to obtain this particular data set?
Well, and we have attorneys contacting us on a daily basis. asking for our assistance with their e-discovery challenges. And the first thing that we do is to congratulate them for taking the step of talking to somebody who can help them with this. And I think for most attorneys, the challenge is to not proactive. The challenge is to be proactive about recognizing that this is a challenge, this is a critical part of the process, it impacts the litigation, and that they need to be involved in ensuring that they have experts who are coming in to assist. So in terms of electronic discovery, I think that the first step is to really partner with somebody who you can trust, and partner with somebody you know has a demonstrated expertise with e-discovery. At this point in the process, the federal rules were revised 5 years ago. There's a well-established body of research. There's a well-established set of technology vendors. There's a fully developed ecosystem around this issue. So to try to sort of get up to speed quickly, to kind of do it all yourself, without outside assistance, is a daunting, if arguably impossible task today. So the first thing is to find a technology partner who you know you can trust, who you know can help you through the process. From a mechanical standpoint, what happens after that is really to send a litigation hold notice to any potentially relevant custodians within your client's organization. So anybody who potentially has electronic evidence that may be relevant to a particular litigation, you send them a lit hold that says, please don't delete all of your files, long and short form. There are plenty of templated, again, if you wanted to just run a couple of internet searches look for templates of what reasonable litigation hold notices look like. There are plenty available kind of in the public domain.
Okay.
The next step, once you've notified people, including your client, that their files are potentially relevant to a litigation, and that the federal rules have mandated that they be preserved in order to be reviewed and produced if necessary within that litigation. The next step is to really talk to the client's internal IT resources, whether they have a department or whether they use an outside consultant, is to sit down with the IT experts and say, we as the lawyers are going to need to review data from available data sources. What are the data sources, and how can you get that data to us? And so there's two ways that can happen. There are self-collections that can be done by a client's internal IT department. Again, a lot of this has to deal with the proportionality standard. If you have a litigation that's worth $50,000 or $100,000, it doesn't make sense to spend $30,000 or $40,000 on outside consultants to come in and collect it. Now, that being said, if you have a very large-scale litigation with a high degree of exposure, then having the client self-collect the data can potentially pose problems in terms of chain of custody of the evidence, in terms of documentation of how the data was collected from the internal servers, and it may make sense to select an outside collection company or individual collection experts, or plenty of certified forensic examiners that have passed certain industry benchmarks who will certify that they can collect data using forensically sound methods. And so that's really kind of the first step, is this identification and collections process, where you identify all the data stores, you notify everybody that there's a litigation in place, and that this data is the potentially relevant data needs to be saved, and go from there.
And on our next slide, we talk about how to manage all of this data that you've now gone out and collected. So kind of first step is recognizing that it's a big project, and bringing in a skilled partner or advisor that can help you with that. And now, once you have it all collected, how do you manage all of this information?
Great. So now you have a collection of data that you know is potentially relevant to a specific matter. The first step really is to recognize that it doesn't do anybody any good to get into a procedural war about electronic discovery. And I think for litigators who want to be, vibrant advocates for their clients, this can sometimes pose a challenge. And so Sedona has sought to really address this issue with what they've issued as the Cooperation Proclamation, which really says that the first step in electronic discovery is to sit down with opposing counsel and talk about it, and to have a meet and confer where you agree on who the relevant custodians are, what the relevant keywords are to extract from that data, what the relevant date frames are to extract from that data, and use that as the baseline for how you decide what needs to be reviewed. One of the things that we have seen increasingly as well is a clawback provision where, in the case of privileged materials that have been inadvertently produced, again, just because of the sheer volume of it, when you've undertaken a reasonably sensible process in order to prevent that disclosure from happening, a clawback arrangement allows you to get that privileged material back and have it and not release privilege on it. And so by sitting down with opposing counsel at on the front end and sort of agreeing on the overall framework of how you're going to go about e-discovery, then you have a sensible baseline to go from. From there, the next step, now you've collected all of your data. You have discussed with your opposing counsel which custodians are going to be reviewing data from and which dates, what keywords you're going to be looking for, is to do a early case assessment. And what the early case assessment is where you essentially you extract only that potentially relevant data based on those keywords and dates. So the challenge here is that if you did not do this process, you're faced with the daunting task of looking through every email that an individual has sent over a period of time. And again, especially now, I mean, with just the volume of emails that you're getting from e-commerce sites, from news aggregators, from the New York Times, from your American Airlines reservations, it's a lot of potentially wasted time in looking through a lot of material that you can immediately identify as not being potentially relevant. So an early case assessment uses those keywords and those dates to extract only those sections out of the emails and the personal hard drives and the personal productivity files of a specific custodian that are potentially relevant. And courts have seen, and lawyers have generally accepted, that a keyword search or a fuzzy or Boolean, there's a couple of other search syntaxes in there, but underlying it is always a keyword search, is forensically sound in terms of giving you a baseline for establishing what data it is you're going to have to review. So you extract the keyword relevant material, and now you are ready to review it. And from there, the process is pretty much parallel to the paper process. You've now carved down your data to what could potentially be relevant, and you have your reviewers, whether they be attorneys or paralegals or outside review companies, go through that data and identify what data is relevant to a litigation, what data is not relevant, what data is privileged, generate a privilege log, bait stamp, redact, and produce sort of in a very parallel manner to the old paper process.
And let's talk a little bit about where our sole and small firms can get EPA review help. I mean, it can be a tremendously daunting task or project that you have in front of you. So there are technology solutions or vendors that are available to help and ease a little bit of the pain of this, gigantic undertaking.
You bet. And I think while e-discovery can feel like a really big and complicated process, the unfortunate thing about it is that it's sort of undifferentiated heavy lifting. It's a bunch of work that needs to get done before the important work of the lawyers can get done. So it is, again, important to find experts in e-discovery who focus on this on a daily basis, who can assist you with this sort of critical first step process. It is a big and growing field. And again, there are plenty of options available to to lawyers who are going out to look for it. One of the things that we've seen, and a number of our customers are your traditional copy shops, your legal copy shops, who are using our products to perform ECA and to host data for review. An option that is available and has been available are local install applications. And so NextPoint is a cloud-based product, so we are a web-enabled product. We don't require an installation of software on an individual hard drive or computer. That being said, that sort of legacy technology format of buying shrink-wrapped software in a box and installing it on a computer, some of those legacy applications remain. Depending on the volume of data, those may be appropriate. And really the most critical issue there is the level of technical expertise. If you are an extremely tech-savvy attorney who enjoys working in the depths of the operating system of your computer, those are applications that may enable you to get your work done through a local install application. By and large, our customers tend to be attorneys who want to focus on their practice and not so much on configuring their computers. And so some of these applications you may have heard of before. Concordance is one of them. Summation is one of them. These were at one time independent software companies that have been acquired by LexisNexis or acquired by Wolters Kluwer, Access Data. Larger companies will then support these products. They generally run, just on a software expense basis, between $2,000 and $4,000 per license to install on a computer, on a single computer. Then you have the issue of networking, backup. So, most of the folks that we see in the concordance and summation environments tend to be in AmLaw 200 firms with, multi-million-dollar IT infrastructures to make those software applications work in a reliable and redundant manner. The emerging set of technologies in the legal industry is very similar to the emerging set of technologies that you see in society in general. We're seeing a move to the cloud, that web-based applications like Google, Facebook, e-commerce sites are really what people are looking for, stuff that works on their cell phones, that works on their iPads and mobile devices and works over a web browser. Is clearly the emerging dominant technology model. That's what we develop. That's the kind of software application, software as a service that we provide. Is we'll abstract out the technical complexity, so that all the software, the hardware, the storage, the processing, all that happens on the web servers, and so our customers can focus on doing their work.
And let's talk a little bit about that review process, taking into consideration what is important, not just for a particular matter or your firm, but for you as a user and for your employees as users. Is mobility really a big issue for you, and is that something that you're looking for, or would you like the security of having all of the information housed on servers in a data center that your firm manages? or has access to. So let's go through some of these review options.
Great. And the question of security always winds up becoming one of the primary ones with when you're talking about electronic data and electronically stored data. And I think for attorneys, one of the challenges is to really, it doesn't take a big technical understanding to recognize that the most exposed that data ever is that when it's sitting on a laptop. So if you have data that is stored on a laptop, it's literally a thing where somebody can walk in, pick it up, and take it. And they have not only the data, they also have the applications to understand it, and they even have a power source. They even have they even have the power source underneath it in order to be able to turn it on and look at it. So and it's parallel really to when you think about it, is kind of like your money. And while it seems intuitive that taking all of the cash that you have and keeping it in a mattress is the safest that it could be, the reality is we all recognize that your money's safer in a bank and stored electronically than it is in cash in your mattress. And really, and that is what laptops and servers in law firms are, is they're literally data mattresses, and they don't provide a secure environment. They are not they aren't stored and backed up in a way, and they aren't secured in a way that is even reasonably comparable to the technologies that are being deployed on internet-based applications. So then the first step after recognizing that your data is safer out of your physical environment and in a highly secured location is to select an application that allows you to review. And again, you want really something that maps to that parallel paper process. You want something that includes fields for coding, that pre-populates it with basic information of to, from, the date, the subject line, the document type. Ideally, your application allows you to segregate the data into multiple sub-reviews to allow additional folks to help you review it. If it's a large enough population, or if the time demands are intense enough that you will not be able to look at all of the documents yourself, ideally you have some user permissioning there that allows you to have a paralegal or assistant or clerk look at some of the information to be produced. And again, parallel to the paper process, you need to have the ability to redact and bait stamp privileged documents and all of your produced documents. This part of the process is much more familiar to practitioners. This part of the process has for the most part not changed to date, and includes exporting privilege logs and other and producing the documents into industry standard formats. So that means you want to be able to, instead of sending over a box of documents, you're going to send over a CD of documents or or an external drive with images like a JPEG or a TIFF or a PNG file and an associated database file, usually a comma delimited file that maps to each of those individual images with the relevant data in it.
And the ability to export and send those out is something that you should actually ask for a demo of as you're reviewing these platforms and applications. A lot of the functionality, if you don't see exactly what you're looking for and have a good understanding of how you would use it by taking a demo, that can give you a good indication of what it would be like from a training perspective. So definitely look for usability of just being able to get in and start working within the application or the platform, because what a lot of times firms neglect to think about is just that initial training learning curve that can take employees from being very productive at what they do to having a delay of a few days to learn a new system sometimes. So definitely take the usability of the application into consideration. Ask them to take you through demonstrations and actually allow you to play with a trial or see how a process would work for your own eyes before purchase, as well as asking for references and then looking at your service level agreement, which are just kind of dotting the I's and crossing the T's before you move forward with the platform.
You bet. And for most of our small firm and solo practitioner customers, one of the primary reasons that they decide to use our applications is because we offer low-cost services to assist in that export process. So again, for, I think, tech-savvy attorneys who really want to do it themselves and build those exports, we provide that functionality. Most vendors, almost all software applications provide that functionality. The question is really, do you want to do it? And if you know you want to do it, then that's what you should evaluate on. If you know that you're going to want to rely on an outside service, again, whether it's a NextPoint or one of our resellers or a reseller of any other application, how much are they going to charge you to help? So, the costs associated with image generation, bait stamp, export can be very significant on the back end of the process. So it's definitely an important thing to look into and try to make a decision on.
So we've covered a lot of information today. We're going to walk through kind of the overall electronic discovery reference model, and then we'll go through a couple of talking points to recap today's session. So we have a graph and an infographic up on the screen. Do you want to take us through just kind of each step along the way?
You bet. And EDRM is an effort, the electronic discovery reference model. You can see there, you can find more information about the project, the electronic discovery reference project at edrm.net. The point of EDRM is to get a vendor-neutral sort of industry-wide standards-making body that attempts to look at each step in the process and, to the extent possible, try to standardize to help lawyers understand the steps in the process and also help vendors understand, to help vendors communicate with attorneys about what the right e-discovery process is. And EDRM has put out, this is the EDRM model, this is their workflow that you'll see with, that people sort of generally come to the point of using, and it has problems with it, but it also is a great baseline, at least, to begin talking about what the appropriate workflow is. So if you are interested more about drilling down into the specifics of each step, again, I encourage you to go to edrm.net. But the first step is information management, is really to work with clients to ensure that they have records management processes in place that allow them to be prepared for litigation should that need arise. So for small companies like like NextPoint, where I'm the CEO, or for my wife's business, who's a retail business. She has a retail store. The kinds of lawsuits that she may face are, an employee. It could be an employee lawsuit. It could be a problem with a customer over a custom order. We've sat down and kind of made sure that she's able to search and archive all of her emails and her desktop files. So that's an information management step, is to sit down with your clients, make sure that they've thought about it, make sure that the IT people are aware that this is a business requirement that may come up at some point down the road. Then kind of once a litigation's been initiated, or seems to be initiated, the identification process is where you identify who the key custodians are. Preservation and collection, we talked about a little bit earlier on this call, where you preserve the relevant data and collect it. Processing, review, and analysis is the review platform component that we talked about, where you convert an electronic file, an email, into an image file that allows people to go in and mark it as relevant, be produced, to be bait stamped. And from processing, review, and analysis, then it goes into production. Again, literally the physical export of the electronic files into a format that can be sent to opposing counsel. And the presentation step is the step at which you would need to demonstrate this evidence either in a deposition, a hearing, a motion in front of the court, or ultimately even at trial. The presentation step addresses what the best practices are as far as presenting electronic data. And again, the day I think of the blow-ups and the and chalkboards and big notepads has gone to the side. Predominantly, what we see in courtrooms today are electronic presentations of documents with sort of 60-minute style pullouts, deposition video, PowerPoint slides, and other sort of presentation tools that are much more commonplace in today's sort of visually enriched environment. Behind the EDRM, you see that they have a declining, as the volume of data declines over time, while its relevance does increase.
And to recap just everything that we've talked about today, any piece of electronically stored information is potentially discoverable. Know where all of your electronically stored information resides, how to collect it, and who can help you get access or aggregate it all together. Manage an efficient discovery process, including ECA, and deploy a review of relevant ESI or electronically stored information with a platform that fits your needs, scale, and budget. Everything from the size and amount of data that you have and that you're tasked with sifting through, the scale and the duration of time that you're going to need to use all of that data, get access to it, and be able to intelligently sort through it, and then the overall budget and term, whether you're going to be using it for 1 month, 2 months, or years to come. Do we have anything else that we'd like to add, or does anybody in our audience today have questions that they would like to ask? Go ahead and chat your questions in the GoToWebinar chat tool, or you can email powerchathelp@totalattorneys.com, and we'll get those answered for you before we wrap up today. It doesn't look like we have any additional questions, so you can absolutely reach out to myself or Rakesh after today's session. I encourage everybody to follow @NextPoint on Twitter to keep up with all of the cool new stuff that they're doing, and you can feel free to email myself or Rakesh directly with questions after today's session if anything comes to mind. Thank you so much for joining us. It's been very, very helpful in understanding the power of e-discovery and how it can be accessed by our firms that use Total Attorneys and are interested in e-discovery today.
You bet.
Thanks, and we'll talk to you again soon. Thanks, everybody, for joining us. Have a great day.